Hello, everyone. Just going to give you a quick rundown. Kuwait passed a law that gives the right to access information. Everyone heard of the law basically. يعني بالعربي قانون حق إفصاح المعلومات اطلاع على المعلومات. When it goes to an effect, according to Article 17 of the same law, the Prime Minister and the ministers, all in what powers they have, should enact this law up to 6 months of the date publishing it in the official newspaper. الجريدة الرسمية اللي هي كويت اليوم طبعا احنا نتكلم عليها يعني. When was it published? The 6th of September 2020. Also, the executive regulation for this law was published on the 4th of April 2021. Now everybody would think that we should run and get all the information we need from the ministries. But hold your horses here. Why we are saying this? Because there could be delays. As per Article 4, every entity should organize, classify, and index the information and document available to it according to the professional and technical principles. Classify what should be secret and protected according to the law within 2 years of the date of the law going into effect. So any entity you go to, any government entity, could tell you that we are still working on organization and indexing the information to see which should be classified and which should be not. Also, entities are obliged to publish on their website within 3 years of the date of the law going into effect a directory containing lists of available information to be disclosed. That means in 3 years, they should have on their website what you can and what you can't have. And there are other information in the law, it says should be on the website. Without even you asking for it, it should be there. Like, for example, the hierarchy in the entity, who are the people responsible, who are the leaders of this entity, you know, like the undersecretary and so forth. What's the steps in this law? The steps start with you asking for information. The information has to be in writing to the entity. Most entities right now are preparing forms. Some of them are already deployed. You can see it like for in civil aviation, you can see their forms. The designated employee should give a detailed report, receipt. Each entity should have a designated employee. And when you ask for information in writing or the form they provided, they'll give you a receipt that tell you when did you ask for the information, what type of information you ask for, how they can contact you. That should be given to you. Why? Because the answer should be provided in 10 days. They can extend that for another 10 days and also for more time, depending on the information they need, the time they need to gather this information. This extension cannot go more than 3 months from the date you ask for this information. Of course, in the case of refusal to provide the information, the employee should give you the writing, give you in writing the reason why not they couldn't give you. He could tell you this information are not available. He could tell you this information are secret. When we say the information are secret or protected, what is secret and what's protected under the law? The law says that this, if the disclosure affects national security, public security, or defensive capabilities, they cannot disclose this information to you. If secrecy is determined according to the Constitution, the law, or the decision of the Council Ministers, the Council Ministers could issue a decision based on the proposal of the concerned ministers, considering the papers they include, and for the period specified by the Council. If the information affects the course of justice or result in harms to others, like if we give an example of a current affairs, if you want to ask about the guy past conviction, we have the current case of what happened, and you want to ask what is past convention? What's his past, conviction? You can't ask because it could affect the course of justice. If the information relates to private or medical life or conditions or personal accounts or bank transfers, you can't ask for it. It's unless the person agrees to it. So if you want to ask about the bank accounts, let's say for a member of parliament, you can. It's under the law, it's secret, unless you get the member of parliament to agree for people to see his bank accounts. If the information includes a trade secret and was liable to be published, weakening the commercial and the financial interests of these concerned, if the information reached the country through another country or organization and its publication would harm relation with that country or that organization, if the disclosure of the information would cause a serious risk, undermine public confidence in the currency or public health or environment, if the disclosure of information caused danger to the life of an individual or his health or safety. If confidentiality is determined by a decision of the competent court or the prosecution, the public, the general administration of investigations. If you people remember, we had a case here in Kuwait, we called it local Jaish. The public prosecution could ask for it to be secret, confidence. And you can't ask because he determined that you can't ask about it. Information related to family dispute and juvenile issues and ongoing investigation in criminal cases. These are the items protected under the law. You can't request this type of information. Notes from the executive regulation. A person, upon acceptance of his request, has the right to access without paying a fee. This is an important distinction you need to understand. You can view the information. You can tell them, I want this information and I want to see it. If you want the documentation, you have to pay the fee. Five dinars for each document. If they are under 10 papers, any paper beyond 10 is a half dinar for each extra paper. Also, if a person request is rejected or not responded within the prescribed period by law, which is the 3 months we talked about before, a grievance may be made to the authority in writing or electronically within 60 days of the date of which he became aware of the rejection of the application or from the expiration of the time limit specified in the law without a response. So if you apply, if you gave them in writing, I want this information, and they didn't answer you within 6 months, you can file for a grievance. And the entity must respond to your grievance within 60 days from the date it was introduced. If they didn't answer this grievance or you don't like their answer, that time you can go to court. And that's a quick rundown of the law, basically. So financial info of government employees is required to be submitted, but not parliament members, whether public or private. Could you explain again? I don't understand your question.
Okay, so I know that government officials, when they take a management position, they are obliged to submit their financial data and sign that all this information is true. Is it the same case for the parliament members that they have to submit their financial data as well?
This financial data as you're talking about, you submit it to Nazaha, and you can't, it's not for the public to see, it's for Nazaha to check. I'm not sure they check it, but it's for Nazaha to check, basically. You fill a form for Nazaha, not for the public, either government or parliament member. And there are some other jobs you need also to fill it.
Okay.
Who decide on the data consideration within each entity? Each entity should have an employee who will determine the classification under the law. Basically, he can't just say this is secret, this is not secret. He should work within the law parameters because as I said, there are certain items they need to be secret. Anything else doesn't fall on it. It's not. You can't make it secret.
في سؤال من عبد الرحمن. These laws apply to both public and private, correct?
These laws are only applicable to government entities and entities that are, the government own 50% of. The company, the government own over 50% of the company, it's applicable. This law will apply to it. The document that the user is requesting, is it physical or digital? Also, there's an recommendation. The document, basically, the definition of document is information that the entity has. You want to see the information. If you want to see it, as the regulation said, if you want to just see it, you can see it. If you want a copy of it, you have to pay the money for it. There's a thing called data governance. I would think it's their responsibility. Yeah. Correct. What Shema is saying is correct. Not all governments have data governance. Some government entities do not know how to deal with data. To be frank.
Forza, there's a follow-up question. He is asking specifically for banks and telecoms. Would these laws apply to them?
Currently, there are no banks or telecom companies that fall under the law because none of them, the government has over 50% ownership in them. So they don't fall under this law. But you could ask, for example, you could ask the Hayat Salat, Citra, for information they have. The law says you can ask any entity for all information it has. So you ask Citra about information they have. You could say this is kind of the workaround on it. Or you ask the Ministry of Commerce about, for example, if you want to ask about the shares in a company, the company will not answer you. You could ask the Ministry of Commerce about the shares because they have that information. Because when you run جمعية عمومية واحد ساعدني شوي عتلي هذه that it has to fall under the Ministry of Commerce.